Yes.
2 p.m. case, Sharma and James Peace, Kalash LLC, trading as Dues Liquors, 2610 Harford Road, Class A beer, wine, and liquor license. Case remanded by the Circuit Court for a hearing only on the motion to reconsider the transfer based on the security plan submitted by the applicants. Everybody testifying, please step forward and raise your right hand.
Do you swear or affirm the testimony that you're... Oh, 1 second. You guys can just raise your right hands right there if you like, it's fine. Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth?
For the record, Melvin J. Knansky, representing the applicant in the case.
Good afternoon. All right, we're here on, and Ms. Hughes?
Susan Hughes, on behalf of Cold Spring Homestead Montbello Community Corporation.
Thank you very much. The board is here on a remand hearing of 2610 Harford Road pursuant to an order of the Circuit Court. And if there's no objection, we'll go with the same order as before. The applicant will begin and the community will be in a position to respond and introduce any evidence that they would like to offer us to consider, subject to our rules of evidence. All right, Mr. Knansky?
Well, the community does have an objection for the record. The community asserts that per Judge Murdoch's September 7, 2012 ruling, in which she ordered that the decision of the Board of Liquor License Commissioners on the issue of reconsideration is vacated and remanded to the Liquor Board, and further ordered that the Liquor Board shall hold an evidentiary hearing on whether to reverse its prior decision issued on March 1st, 2012, denying the transfer of a Class A license for 2610 Harford Road, and further ordered that open costs are to be paid by the Board of Liquor License Commissioners. Judge Murdoch furthermore ruled verbally from the bench that the Liquor Board violated procedural due process when it didn't allow full testimony during that March 22nd reconsideration hearing, and also she stated that the Liquor Board's decision on the reconsideration was improperly reached because it wasn't based on substantial evidence. The community asserts that based on that testimony, based on her verbal findings and order, that this hearing today should include a full hearing on the transfer as was done on March 1st.
Say that last part one more time, please, because we don't have that. Obviously, we don't have that. We just have the written order. So tell me the last paragraph that you said.
Based on Judge Murdoch's verbal findings and her written order, it's the community's assertion that today's hearing should consist of a full evidentiary hearing as was ordered by the judge, and not limited to the security letter, but the hearing on the transfer.
All right, thank you. Mr. Knansky, first, would you stipulate that Judge Murdoch made that statement from the bench?
No, she did not.
What do you think she said?
Well, I'll read the excerpt if you want.
Please.
It says, the court, I've reviewed all the written submissions of parties and reviewed the transcripts of the proceedings. I do agree with the petitioner in this case. Procedural due process was denied when the Liquor Board used evidence given to it after the March 1st hearing for the basis of its reconsideration of its decision to deny the license. That was the letter submitted with regard to the security plan. The Liquor Board appeared to find, in fact, that the factor of impact on the general health, safety, and welfare of the community, not the public need and desire for the license, was a compelling factor in denying the March 1st request. Then the Liquor Board received ex parte evidence, which was the evidence that we submitted the last time in October here that the judge didn't feel was part of the record, to show that the safety measures had been taken to quiet the safety concerns of the neighborhood. In this court's view, the Liquor Board's decision on reconsideration is unsupported by substantial evidence in the record, which was the fact that the letters and the plan were never submitted as part of the record. This case must be remanded to the Liquor Board for the purpose of correcting this deficiency, which is the deficiency with reconsideration. They're required to explain clearly the basis for the decision using the statutory factors, and for these reasons, I will in fact vacate the decision of the Liquor Board's commissioners on the issue of reconsideration, remand this case to the liquor board in order they hold an evidentiary hearing based on this decision to reverse the prior decision based on March 1st, denying the transfer of the license. That was taken right from the record.
Can you refresh my memory, or give me the evidence, well,
Do you have copies of that?
the evidence,
Yeah, we're going to need that to go into evidence.
That's it. All right.
you have it? Or you've already submitted it?
No, I already submitted it. I sent it over to the board. No, you should have it there. Wait.
Well,
Wait, 1 second, please. I just want to be clear. What are you submitting?
This is the judge, what the judge said,
Right, that.
and then her decision.
But I'm referring to the ex parte evidence that Judge Murdoch referenced.
The judge was referencing my letter of the security plan
That
that was
was,
sent. The board made the reconsideration, said it wasn't part of the record. I asked it to be made part of the record because that was the evidentiary part of the hearing.
and your assertion is that's what the judge has determined was a due process denial to the community because it was received without their knowledge, their input?
Was received, and they received a copy, but then the board had us back here on the 22nd of March and had a further hearing, which the board then
Reversed
reversed.
its decision
Right.
upon reconsideration and submission of the evidence, and at the time, the community association received a copy of it.
Right. It says again, the licensees will be restricted by the letter of March 6, 2012, in consideration one. Additionally, they'll be responsible for exterior cleanup and so forth. That was,
Okay. I'm all caught.
I have no copies of what you submitted to the board.
Make sure she has a
I
copy.
haven't submitted anything to the
A
board.
copy of the letter of the security plan outlining,
That was submitted when we were here in October,
You-
as you remember when,
okay.
I mean, you may have marked it as an exhibit.
So what don't you have a copy of?
Any of this that he's talking about?
Well, what do you,
What's the pronoun this standing for?
Saying he, because as the attorney,
Yeah, I am.
he's supposed to send a copy to opposing counsel as well.
Oh, the extract, I mean,
I do not have the transcript that he just mentioned, and by the way, I don't know where you came up with security, I don't see it written. And,
what are we referring to? So are you
This is
referring
the
to the
this is-
judge's
yes,
decision?
yes,
Okay,
sir.
the transcript of the official proceedings before Judge Murdoch of September 7th of last year.
Which was the hearing.
All right, so do you have an objection to the admissibility of what the judge is directing us to do here?
I would like to have,
All right, go ahead and, you want to go through that? I'll give you a second too. But yeah, I mean,
We
the
need
board
one.
is desirous of that information.
you have 2 copies now. So one would be for you. Mr. Kudinski, you have one for the board. Chairman.
I'm just going to lay this down here until Ms. Hughes gets a chance to look at it. So, Mr. Kudensky, based on that transcript, what is your understanding of the nature of this hearing?
Was only to take testimony on the evidentiary hearing with regard to the security plan. Because that was a reconsideration, that's what the reconsideration hearing was all about. Had nothing to do with anything prior to that.
All right, the board, I mean, is hearing
Quick things.
a paraphrase, as well as can be expected, from Ms. Hughes of the judge's decision, but there are 2 parts of that that are operative for the board. I think you said, Ms. Hughes, in your paraphrase of the judge's decision, that she called for a full evidentiary hearing.
well, that's what the order says.
The order doesn't use the word full. It says she'll hold an evidentiary hearing on whether to reverse its prior decision.
Right, of March 1st.
Right, and that doesn't necessarily
March
indicate
22nd.
a full rehearing of all the issues from the prior hearing. It's an evidentiary hearing on whether or not to reverse our decision. And why should we reverse our decision? Do you disagree with that?
I'm reading the excerpt of her proceeding, and she states, in the court's view, the liquor board's decision on the reconsideration is unsupported by substantial evidence in the record. Therefore, it's unreasonable and arbitrary, and the case must be remanded for the purpose of correcting this deficiency.
Right.
They are required to explain clearly the basis for the decision using the statutory factors. Now, I take that to mean the March 22nd reversal. Because you found on March 1st that there was, based on the testimony, my clients, that there was no public need for this license at 2610. And then based on Mr. Maslin's ex parte letter to you and the board, and Mr. Kadensky's ex parte letter to you and the board, all of a sudden, everything was reversed, and Ms. Schroeder sent Kadensky a letter saying, send us, if you agree to the security plan being
Please
put on
take
the
that
record.
outside. All right, Mr. Kaninsky, give you a chance to respond to that.
Basically, you had a further hearing on March 22nd, which the board then considered the letter and the security plan. The meeting was present and represented by counsel. At that point, I'll make this, I'm sure it's part of the record, but you had indicated there was no further, went into the decision phase, no further testimony, and you made a decision that based on the security plan, that you then granted the transfer of the license. Case as a court of special appeals.
Thank you.
And I'll submit this as part of the record. It says where the same parties are, same commissioners are here, the case is remanded. It's only remanded for that very specific purpose, and nothing further than that. This was a case, came out of a zoning case in Baltimore County.
Well, there's also case law. I'll wait till you finish.
So, just want to be clear. Your argument is that the board found on March 1st that there was no public need. Then on March 22nd, 2012, the board found a need based on the voluntary restrictions that was provided from the security plan.
Based on the 2 ex parte letters from opposing counsel, and the security plan was included in one of those letters from Mr. Kadensky.
So your
And
argument,
based on that, the board completely reversed and would not allow testimony from the community, and didn't, from the transcript, the chairman said that based on Mr. Kadensky's submittal of the security letter plan, now there is a public need. I believe you said that on the record. But the fact is, what does that have to do with the fact that you already found that there was no public need? What does a rudimentary drawing with some cameras on it, how does that change the fact that the public does not want or need the license, the store, the operation of the liquor establishment at 2610 Harford Road? The security plan was never mentioned at all by my clients in their testimony. It was the fact that we have enough liquor stores in this neighborhood, the fact that we have a problem with alcoholism in this neighborhood, the fact that we're trying to clean up this neighborhood, we have enough. Also, the owner of the church is here, and he does not give his approval to have the license operated at the premises based on the fact that the church believes that there was a misrepresentation made when they signed the lease with Caliash LLC. And the fact is, they never gave their permission to the board or Mr. Kadensky to install the security plan that he has submitted to the board on the, I believe it was the 6th, I believe it was.
Let me say,
What would you like to say? 'Cause I've got something to say
I'm saying
after
that
that.
the lease has nothing to do with what we're here about. They've been paying the rent, never got a letter from the landlord about anything, and they accepted the money. That's not an issue in the case. What the board said on March the 1st was that they would keep an open mind and that they will, reconsideration. The applicant offered some kind of confidence security plan, which was then submitted to the board. The board then took the security plan, which was the letter of March the 6th, and approved. However, the community wanted it done in open an open forum. That's when the board had the open forum on March the 22nd.
Excuse me.
And reversed. And reversed.
You gotta remember to do that. Let's cut to the chase. The board was here in all of these cases. And what we said, let's make it very clear for the record. The community wanted your client to sign an MOU. You said no. Am I right?
Did say no.
Okay. Then the community said, well, then we're against it if you won't sign an MOU.
Now, let's just stop right there. Not the community.
Oh,
A community group, because
Hear me
it's in
out.
the
The
record-
Protestants,
Yeah,
hear me
there
out.
was
The
only a
Protestants,
portion of the community.
those who appeared at this hearing, because an MOU was not signed,
Which is not required to be signed by the rules and regulations.
please let
Okay.
me finish. That based on that they were opposing this project. One of the key provisions of that MOU was a clause regarding security.
Correct.
You were unwilling to agree to terms, at least as of the original hearing date, terms in the MOU. The community therefore opposed it. The board denied the transfer, but made it very clear on the record, so as not to surprise anyone, that we would state that the board will keep an open mind on reconsideration should the applicant be able to offer the board some kind of a confidence security plan and anything else the applicant may deem necessary in that application for reconsideration. So we denied the transfer. Your client presented a security plan. Pursuant to the last thing we said on the record, in the hearing of March 1st, 2012, the board went ahead and reconsidered and approved the transfer based on what we believe to be an adequate security plan. The community did not have a chance to defend that decision, and therefore that was the basis of the appeal, in which they alleged that we, and the judge found that we had denied procedural due process. But it was no surprise that the board would in fact consider a security plan on reconsideration. So based on all of that, and based on what the order says, based on what the judge's oral opinion says in the transcript, which we are going to go ahead and admit into evidence today, as it is it's germane for the purposes of our remand hearing. It's the reason we're here. We are going to limit this testimony to an evidence, or we're going to limit the evidence in this hearing to the security plan. But I do believe the board is required to address or to go over the transcript to determine public need and desire, that we have to at least address that issue. But but it is not a de novo hearing. So we're not going to address every factor. I don't think that's the intent of the judge. And if we're wrong, we'll get this case back. But that's our understanding based on the order we have, and based on what's now the oral opinion, which the board was not aware of until today, what exactly was said. So we're going to start this remand hearing, and the first thing we're going to do is we're going to hear about the security plan. Mr. Kaninsky, you can start.
We submitted the security plan in October when we were here, and you marked it as an exhibit. Right before Ms. Mary Pat Clark came running in here, I want to know what's going on. So I was very clear to have it marked as an exhibit along with the letter.
You'd like for us to produce that?
Mary Pat Clark also, we agreed to accept into evidence a letter from her when she was here at the prior scheduled remand hearing prior to the holidays, dated December 19th, and it addresses the issues of the security cameras and the security plan. So we'll go ahead and receive that letter, and it's the protestant's first exhibit. It's received if anyone needs it for...
I have copies.
Okay, just to remember, what it says. That's received into evidence by the protestants. Now, the board's also taking notice of the March 1st, 2012 transcript of our original hearing in these proceedings. Is there any objection to that?
You have the March.
We have the December 19th letter from Councilwoman Mary Pat Clark. That's already in evidence as Protestants 1. Agencies 1 will be the transcript of the hearing of March 1st, 2012. And we'll also need to put into evidence the reconsideration hearing of March 22nd. It's the agency's second exhibit.
Your letter, your March 6th letter, you asked for it
Yeah.
for us to. You're gonna
This was,
Okay. Do we have the March 6th letter? Can we have that?
you had marked it the last time, I'll give it to you. On October the 25th, 2012, it was marked as an exhibit, along with the exhibit back. I resubmitted this time.
Applicants, one in the remand hearing is received, it's the March 6, 2012 letter from Melvin J. Kadensky. Applicant second will be People's Council versus Country Ridge Shopping Center, 2002. Board of Special Appeals matter.
excerpt.
Applicant's third exhibit would be the transcript of official proceedings, excerpt of the proceedings from 9:39 a.m. to 9:41 a.m. And that's the applicant's third. In that, I just want to point out that Judge Murdoch indicates that we've appeared to find the impact, the factor of impact on general health, safety, and welfare of the community, rather than the public need and desire, was a compelling factor in denying the request. And then the board received ex parte evidence to show that safety measures had been taken to quiet the safety concerns of the neighborhood. All she's asking us to do is to support our decision by evidence on the record. And that's why it's remanded today, and for us to explain clearly the basis for the decision using the factors. So, who wants to testify about the security plan?
We'll submit the security plan as the exhibit.
I'm sorry. Dual liquors. I have already installed cameras there. 13 of them are already working there. And I have big lights which stay open all night long. When I saw the camera last night, and most of the time I watch cameras, I see people walking on my side instead of walking other side of the road because it's dark. They feel more safe. And I see the system I have put there, still, I can show you, it's on online. I talk to customers, they feel more safer.
The cameras that you have put in, you have replaced the existing cameras, is that right?
I have already replaced the camera. I just added 2-3 cameras more, but I replaced the camera with more better capabilities. You can see it's on online. I can,
Very nice.
All right, and you're able to monitor that from a remote location?
get from home, from my car, anywhere.
I'll take a look at the store.
Excuse me, sir, can you restate your name, please?
Surinder Kumar.
Could you spell it, please?
Surinderkumar. Kumar.
Thank you.
This is occurring right now.
That's live, yeah.
Can I see that, please?
And Mr. Kudensky, how long was this premises operated, selling off-premises packaged goods?
I think since 1935, according to the records.
Thank you, sir.
Was it a drugstore?
At one time. I mean, I'm not that old, so I can't remember that back that far, but. Now, along with,
What else? You got cameras, motion lights?
Lights.
now you don't have motion lights, your lights are on all in 24 hours.
These are not motion lights, they stay on all night long, you know, they are dusk and dawn lights.
You have the
And I have a guy from security, community, he cleans 3 times a day, you know, every day. Even if it's closed on Sunday, and you'll be surprised to know he's cleaning almost 1/3 of the block, even up to church. Church is like 2-3 houses away from there. He cleans across the street too. So he cleans 3 times a day.
Maybe we would like to object to the witness's testimony based on the fact that, who really are you? Are you an applicant on this?
She's the owner.
That's a fair
I'm
question.
her husband.
And are you, according to this applicant's interview form, you do not
Excuse
want
me.
to be on the license?
You need to speak into the mic,
Speaking of mic,
please.
please.
According to the liquor board's applicant interview form, the applicant, I assume to be your wife, states that
They need another one.
you do not want to be on the license. And so my question is to the board, what is Mr. Kumar's standing to testify in support of the transfer when he isn't an applicant, he isn't on this
Fair
license?
question. He obviously has some
I'll be
information.
operating- Because I'll be operating the business. She's on the, you know, license on.
I'm sorry.
Who's been operating the business since you've been in there?
Uh,
You have been?
Mr. Kumar, is your English better than your wife's English? I mean, is there another reason that you might be speaking to us today? Okay.
Now, let me ask you this, regarding, you were at a community meeting with me and your wife
Yeah.
and Mary Pat Clark and Mr. Washington, weren't you?
Yeah,
So we went to that community meeting
Yeah.
in Cold Spring.
Yeah.
And we went over all these issues.
yeah.
Is that correct?
Well, I'm surprised, when we first time met, the only issue was, can you stop selling miniatures and shorties?
I don't want to hear about that right now. We're just talking about the security plan.
We had submitted a letter in which you had indicated that you had 16 infrared cameras. How many of those are installed now?
13 are already working.
All right. Each camera will have a high-quality surveillance up to 65 feet.
It's more than that,
All right.
75.
And the camera will be waterproof?
Yeah.
All right? The surveillance zoom will be able to get a better picture of an object, the
Yeah.
person, correct?
Yeah.
Recorded video will be downloaded with a flash drive?
Yeah.
Has anybody ever come in and asked you for any other?
No.
Number one. All right.
Ask you what? I'm sorry.
Asked you for a download. Live surveillance, you have that now?
Yeah.
All right, and instead of motion lights, your lights are on 24 hours?
They are on 24, I mean, just day and night.
Dusk to dawn. Okay, and along with that, besides your lights, doesn't the city have a blue light there also?
There's a police camera right in front of the store too.
All right, anything else
No.
from Mr. Kumar? All right, any other questions on cross-examination for Mr. Kumar before we'll go to you?
Did you receive a written authorization from your landlord to install 16 infrared cameras and?
No, ma'am.
I'm going to object. I think there's any relevance in this hearing.
Basis, I mean,
If it's a lease issue, it's not an issue of, the cameras are up there, he received
I just replaced the camera.
no, please, your attorney speaking.
Receive anything from the landlord saying the cameras he put up are not acceptable or anything else. It's a lease issue, it's a complete civil issue, it has nothing to do, if it exists at all.
Well, I'm going to overrule your objection. I mean, I think the point, I think we need to know as much about these cameras as we can, including
cameras
whether or not
themselves.
they're acceptable to the parties who own the building.
And also under Article 2B, 9105, requirements or specifications for premises. No license shall be issued for premises which do not conform to any requirements or specifications given elsewhere in this article. Furthermore, 10103B, every new application for a license shall be sworn to by the applicant and shall contain the name and residence of the applicant, how long he's lived there, Also, down to 10-103-17I, the application shall include a statement that the owner of the premises assents to granting of the license applied for and authorizing the comptroller and inspectors and police to inspect and search without warrant of the premises. And the fact is, the landlord does not give that authorization.
That's sustained. That's sustained. Do you have any questions for Mr. Kumar?
No, I don't have any questions for Mr. Kumar.
Thank you very much, Ms. Hughes.
Substance of our case with regard to the remand.
All right, and Mr. Kadensky, when were these cameras installed? Specifically, what date?
2 months back.
2 months after the initial hearing?
I think in last 2 months, I think, 2.5 months. Yeah, cameras are there, I think, more than last 2 months.
Okay. All right, any other evidence at this time?
The cameras you put in, you were just replacing the cameras that were there.
I put the better capability cameras. Cameras were already there when I came in.
Okay.
Now, nothing further.
Ms. Hughes? Anything you'd like to say vis-à-vis the security?
Yes, under 16405, to be 16405 regarding inspections and searching without a warrant, the property owner does not give its permission, and that is, we assert, relevant to the security plan. The landlord, the owner of the premises, did not give and does not give permission to install these cameras that, as of your March 22nd decision, were...
Can I object? Are you representing the landlord here?
I'm representing the community.
No,
And
you're a
the
community
landlord
group
is
you're
here to
representing.
The landlord is here to
All right, the
speak.
landlord can speak for himself if it's relevant, and at this
And
point, it's not relevant.
It is relevant, and the fact is, this board is charged with making an investigation into the application. And the fact is, the owner of the property has to assent to the search of the premises, and the owner of the property doesn't. So as the community's attorney, we are here to, in addition to object to the fact that this hearing should not have been limited based on the court's ruling, also, we are here to show the board that this transfer should not and cannot occur because of major omissions and inaccuracies, or maybe even false statements in the application. You cannot have a liquor license operating at a property when the owner of the property will not give permission to have inspectors come in, and that's a fact. And it doesn't matter if who I'm representing, that's a fact that has to be acknowledged, and it's been put on the
At this
record.
point, I gotta
Your
object.
objection is sustained, Mr. Kadensky.
completely irrelevant.
Your objection is sustained, sir. All right. We are sustaining the objection. These are issues that were not raised at the first hearing. The board did review the application at the initial hearing. These were issues that were not raised on appeal as well, nor are they addressed by the judge specifically for the purposes that we're here for today, for a remand hearing. So we're sustaining that objection, and we won't be considering that evidence today.
So the fact that the security plan that you say the judge is limiting this hearing to, the fact that the security plan, the owner of the property has not given permission for the security plan to be installed at his property has no bearing on this? And the fact that regardless of whether, first of all, the community wasn't able to give testimony on the 22nd, they weren't allowed to speak regarding the deficiencies in this application. And the fact that it comes...
They could have spoken about it on March 1st.
But they weren't attorneys. And now there's an attorney here representing them that's basically doing the job of the board, that's picking apart this license and saying none of this works. How come Mr. Pease, the applicant, is Mr. Kadensky procured him? He doesn't even live in the city. And the community has records here today to show that. So how in the world an application for transfer can be approved when the information in it is completely incorrect, false, I don't know. But the
gotta
fact
object.
is,
We're going
somebody
over the
has a
same thing
duty
over and
to
over
go
again
through this
here.
application to make sure that it's legitimate and it's accurate. Because when the community has a problem with this establishment, is Mr. Pease going to be available? Does this applicant even know Mr. Pease? Why isn't Mr. Pease here? And under Article 2B, the board, the chairman has the authority to summons him to be here. And the community has questions for him regarding his residency, his voting his voting status, and also the people that swore on this application that they know him, he's in good character. Are those people even Baltimore City residents? Because in a very cursory investigation, it sure as heck doesn't show that they are, according to Maryland land records and according to State Department of Assessment and Taxation. And this can't be swept under the rug. It shouldn't be, because this board's charged with this. This is,
This thing over, and I'm objecting because you're putting a lot of things in here. It's not even what we hear about it. Because they didn't have somebody here on March the 1st, whenever, it's not for me to say. You've had numerous attorneys in this thing since then. You're one of them. They had 2 other ones in here. None of these issues have been raised. Now, all of a sudden, every time we turn around, there's another issue. We're only
Your
relegated to.
objection is sustained, Mr. Kudensky. We are at a position here where we are going to, based on the evidence that's already in the record, going to clearly explain, as the judge asked us to do, the basis for our decision. If you have anything else to offer regarding the security plan, regarding public need and desire, regarding general health, safety, and welfare, that is consistent, right, with that's not duplicative of the testimony that was already introduced and put into evidence by the community almost a year ago, be my guest. If anything else?
so it doesn't matter. The board doesn't, it doesn't matter that no one lives in Baltimore City that's on this application?
The application as of March 1st, 2012, that the board determined at that time, I mean, the board didn't have any objections to it at that time, nor were any objections raised by any of the parties. So the board is not going to consider that information today.